Welcome to the fourth in a series of CLE webinars. Today we're going to be talking about ethics. But first, let me introduce our other panelist. Kim D. Ringler has focused on attorney ethics as a practitioner, disciplinary prosecutor, and member of the adjudicatory committees for more than 30 years. A graduate of Oberlin College and Georgetown University Law Center, she was deputy director of the New Jersey Division of Consumer Affairs, in charge of all professional and occupational licensing boards. She also served as legal ethics liaison officer for the New Jersey Division of Law in Newark, New Jersey. She provided guidance on conflicts of interest and other executive branch ethics issues. As you can see, Kim is, among other things, an expert on attorney ethics. And that's important because when an attorney acts as a mediator, the rules of professional conduct carry over to them in their mediator role. Welcome, Kim.
Thank you. My pleasure to be here.
This is not going to be the usual panel where we tell you things and then you ask questions. We're going to pose hypotheticals to you and you're going to provide the ethical analysis. You'll do this by raising your hand. I'll recognize you. Don't forget to unmute yourself when that happens. Kim and I are here to guide the discussion and to add anything additional for you to consider. When you're talking, please distinguish between whether there's an ethical issue, something is a bad idea, or whether you would or wouldn't do something because of potential liability. Okay. So with that little preamble, let me mention one other thing. There will be 2 attendance codes, which I will read somewhere randomly throughout this presentation. If you have purchased the CLE webinar package, you need to write those codes down. There will be no Q&As, there is no chat. It's going to be raise your hands. So with that, let's go into the first hypothetical, unless you have anything else to say at the beginning, Kim.
I do not.
Okay, so actually it's the first part of this presentation, which is a short PowerPoint. Okay, so let's define ethics. And you can see on the screen, it's a system of moral principles, the ethics of a culture, a set of rules of conduct recognized in respect to a particular class of human actions or a particular group, culture, etc., medical ethics, Christian ethics, and we can add mediator ethics. An individual's moral principles, her ethics forbade portraying a confidence. It's a branch of philosophy dealing with values relating to human conduct, rightness and wrongness of certain actions, and with the goodness and badness of both motives and ends of those actions. So what is it for a mediator? Well, you have to look someplace for standards and to guide what an ethical standard is for a mediator. And I've just listed some and I sent them out to you as an attachment to a listserv email and asked you to read them. The first is NJAPM standards of conduct. There are standards for conduct for court-connected cases. There are model standards of conduct. There's Rule 1:40 and the New Jersey Uniform Mediation Act. All of these are places where we can look to for ethical standards. And of course, Kim is most familiar with the rules of professional conduct.
Yes, I need to interject there to emphasize, as you stated at the outset, Carl, that when a lawyer engages in mediation, that is part of law practice. It's law practice that's limited in scope and needs to be clearly defined and understood by everybody who's participating. But the rule, if a mediator is also a lawyer, the rules of professional conduct, as well as the Supreme Court rules, do apply and are an important source to look for standards of conduct.
Okay, so let's go on to the very first hypothetical. I'm going to read it for you. In an employment discrimination case, the mediator learns in a private caucus where it's been agreed that everything said will be confidential that the plaintiff was recently arrested for the possession of illegal drugs. The mediator inadvertently discloses this information to the opposing attorney during another private caucus. The mediator immediately realizes what she has done and thinks she will be sued for malpractice. Does she have an ethical/legal problem? What should she do? Okay, now I would like people to raise their hands. And if you do not raise your hand, then I am going to call on people to address this. So anyone want to raise their hand, volunteer to answer on this?
Or at least underscore what the issues raised might be, even if you don't have readily available the actual answer. How would you go about analyzing this to get to your answer?
Exactly. So I don't see any hands raised. So I think I'm going to have to call on Bruce Mattez. Bruce, are you there? And if so, raise your hand. Thank you, Bruce. Okay. Bruce, can you talk?
How about now?
Yes, excellent. Bruce.
Okay, sorry about that.
Okay.
So I think the issue really starts with a disclosure in the beginning of, are those caucuses confidential? And I don't think I've started to look through the different forms that you've sent us with the rules and stuff, but I don't think there's anything that specifies whether the conversation that takes place privately in a caucus is confidential from the other party. I think that's a contractual thing that has to be established between the mediator and the parties. So in my mediations, I'm very clear with people that they should not disclose something to me in a private caucus that they do not wish me to disclose to the other person. That if they do, I will either have to get permission to disclose it to the other party, or I will withdraw as the mediator.
Now, the fact pattern is that the mediator, it has been agreed that everything said in the private caucus will be confidential.
Oh, sorry, I missed that. Sorry about that.
No, it is confidential.
Then I think if the mediator just says it's confidential or agrees that it's confidential and discloses it, then the mediator has an issue, has a problem.
Okay, is it an ethical problem? Is it a legal problem? What?
I think it's an ethical problem because there's been an agreement that the mediator would maintain the confidentiality and has violated that confidentiality.
What should the mediator do?
That's a good question. Well, I think the first thing, so I can't see the full, I can't see the fact pattern, but I think the first thing is that the mediator needs to disclose to the party who made that disclosure, the party that was arrested, needs to disclose that that the disclosure was made to the other party.
Okay.
At the very least, that has to happen.
Okay, and is that because that's required ethically, or is that more of a mitigation type thing?
I think I would imagine it's required ethically, but again, I was looking through the different rules, and I don't see anything that specifically covers it, but it's hard to scan everything at one time. So I think ethically, yes, that would have to be disclosed.
Okay, what would the mediator do anything with respect to the attorney that he disclosed it to or she disclosed it to?
Oh, I don't know. I don't.
You want to clarify whether the inadvertent disclosure by the mediator was only to the attorney on the other side, or it was to attorney and that attorney's client?
Only the attorney. Only to the attorney.
So Does that raise any issue, I wonder, about the possibility of something analogous to a clawback or sending metadata when you didn't mean to? Bruce?
Well, doesn't that attorney then have an ethical obligation to his or her client to disclose that information? To me, that's the first thing is that attorney, I think, absolutely has an ethical obligation to disclose it. I don't think that attorney can say to the mediator, yeah, it's okay, I won't tell my client. Then that attorney's getting themselves into some hot water.
Is the attorney who disclosed it also have a problem? After all, that attorney disclosed something that really should not have been disclosed.
But that attorney, the attorney who disclosed it in the mediation, in the caucus?
In the caucus.
But that attorney was operating under the assumption that what was being disclosed was confidential.
Yes, but it was an irrelevant fact. It was something detrimental. Perhaps that attorney shouldn't have mentioned. Is that a problem?
That it's not relevant to the issues that are being discussed?
It is relevant, but sometimes you don't want to disclose all the facts, I assume. And
I don't think it matters whether the fact of the matter is it was a disclosure, and the disclosure was made under the guise of confidentiality.
Okay.
Do you think it matters that the nature of the information disclosed is a matter of public record? An arrest technically is available to anybody. That's public information. And it would be likely to be discovered inevitably should the case turn into a case. In an employment discrimination case, the defendant is going to take all kinds of investigatory steps to find out about anything negative about the plaintiff who's alleging employment discrimination, like maybe doing drugs.
Well, but the fact pattern says was recently arrested. So perhaps it hasn't become public knowledge yet. And they're in a mediation where the objective is to resolve the matter, right? So it's not like a long-term, yes, eventually it will be disclosed, but they're doing it today.
Yeah, I'm not sure it matters. I'm not sure it matters whether it's a matter of public record or not.
Mm-hmm.
Okay. So Kim.
We have a comment that came in, I know from Barbara, who says an arrest is a fact and public information. It is not secret nor confidential.
But again,
true, but it may not impact the decision making by the meeting.
The other parties may not know about it yet, and they're there to make to resolve the issue, settle the issue. Right.
To me, it's relevant in that the attorney for the person who's been arrested knows they need to reach a resolution because they've got a potentially explosive negative fact down the road. So there's more motivation. It's kind of a statement against interest to the mediator. That lawyer has more vulnerability perhaps than the mediator.
So, Kim, does it make any difference whether the mediator was an attorney mediator or just a regular non-attorney mediator? Are there any RPCs that might apply here?
Analogously, I mentioned that, the old-fashioned adage, if people were perfect, pencils wouldn't have erasers, right? So this is probably an error on the part of the lawyer who disclosed it. And lawyers are allowed to make certain mistakes without it being unethical conduct. And in an instance where, for example, discovery is provided and there's something in there that shouldn't have been turned over, lawyers can say to their adversaries in that context, hey, give me that back, I'm clawing it back, or they have an agreement ahead of time, I'm giving you 6 billion pages, and if one or the other of us determines that we were overly productive, we'll forgive it. So I don't know the answer in this context because of the absence of a specific, RPC. We know that this is a matter of law. Bruce mentioned that there's an agreement. It's a legal contract. They've all agreed to participate in this mediation pursuant to certain terms. And one of the terms is that the caucus conversations, the private caucuses, are going to stay confidential between the mediator and the person who's participating in that private caucus. So the mediator did disclose, but I don't see any prohibition beyond the contract. And that's not insignificant, but that's a matter of law, not a matter of ethics.
Okay. So we have Barbara Lighting who would like to ask a question and make a comment. Barbara? Whoop. I'm sorry.
Well, I thought that since it is a fact that he was arrested, that that would enter into your conclusions here. But I'm wondering if we could just back up a bit. What if there is a contract between the mediator and the two parties that their information is confidential and will not be shared? Why is the mediator present at all?
Well, if what you're saying is the mediator should withdraw at that point, or at least offer to withdraw, other people in the questions and posed on the chat are asking that question. That's, I think, a very valid response to, now what should I do as the mediator? And guiding principles are generally that transparency is good and acceptance of responsibility is good especially when there's actually been a misstep. So saying to the parties, I may have made a disclosure that violated our confidentiality agreement. And so I'm prepared to step back and you guys can start again with someone else.
So let me ask you, it's clear that the mediator violated confidentiality and therefore is an ethical problem. Does the mediator also have a legal problem for breach of contract?
I think that's the predominant problem.
Okay. And is what you're suggesting?
I mean, it's certainly the evidential privilege does not attach. Yeah. But the ethical duty under RPC 1.6 pertains to information received when you represent somebody. And it's very broad. What kind of information? It's all information relating to the representation must be kept confidential, and only the client can waive or give up that privilege. Mediation is not that type of a relationship. The confidentiality obligation does not attach. It is purely a creature of the agreement, a legal agreement. And there's been a definite breach there. So I would say that you're mentioning the legal problem as a big predominates in this situation.
So is your suggestion, and I think Bruce said it also, disclosure to the party, the other party, actually both parties, is that an attempt to mitigate any potential damages by showing your willingness, being a good person, et cetera? Is that a mitigation attempt?
It's a mitigation attempt. It's also a good business decision.
Well, right, but
and the whole thing is later found to have been a waste of everyone's time. You're certainly not going to earn whatever your fee was. You'll have to disgorge that.
Right. Okay. One more, Jay. If you unmute yourself.
Hi. You hear me?
Yes.
Okay. So I just indicated in the Q&A that the genie is out of the bottle. Once you've made the disclosure, that other attorney is going to disclose it to his client. I don't care. In the privacy of the two of them, somewhere it'll be disclosed. The point of the matter is, I think once you've disclosed it and you had a violation of the confidentiality, I believe the mediator should resign. Now, whether or not there's a legal question of breach of contract, I don't know. I'm not an attorney, so I can't comment on that. But certainly, like it was said, the mediator resigns, doesn't bill, or gives back refunds any money that he may have already billed for and gotten paid on, and
hope for the best.
that makes everybody whole with respect to where they were at the start of the mediation.
What, Jay? Why would the mediator have to resign? Isn't that up to the parties? I mean, they might.
I think he or she should not leave it to the parties. I think, given the fact pattern as was stated, I believe it should be the mediator who should take the initiative and resign.
But if it's just a mistake, and everybody makes mistakes, and it's disclosed to the parties, and the parties say, "Yeah, let's go ahead," isn't that?
I would, if it were me, I would feel uncomfortable.
Okay.
I would say that. I would feel uncomfortable staying on as the mediator. Hopefully, I'll never be in that situation. Okay, but having said that,
Right.
I think that I would, if it was me, I would resign. The same way I just got a case. The law firm on one of the party, the law firm being sued actually is a firm I am quite familiar with. I have to call the plaintiff and see if they'll even agree to let me continue. But you make full disclosure, and you just walk away, and you hope that once you've made everybody whole to where they were prior to the start of the mediation, that no one will go after you for breach.
Okay, let's. I have one more question in this. Then we're going to move along, and let's see who was the next person. I thought.
Brad?
It was Anju, but Mark Annette. Okay, Mark.
Hi. By the way, I think it would be helpful if you occasionally reposted the thing up there or left it up longer so we could, the fact pattern, so we could copy it and to our screen. But I actually think unless it was publicly available information, the mediator has a legal question, and the potential for them suing of damages for any time throughout the mediation, if it ends up being damages, is too great. They have to withdraw. They can't unless it was publicly available information. Then it becomes an ethics question, and then they can offer to withdraw and leave it up to the parties to decide whether or not to pursue it. But again, the fact that they have violated the contract, which opens them up to damages, and at any point during the mediation or afterwards, they can potentially come back and sue them and say, were it not for this disclosure, we would not have had this component in our damages.
Okay, Kim, anything, the final word on this one?
No, but I think there are a lot of important considerations that have been raised. And as you started at the outset, there's a big overlap between what the law says, what codes of ethics say, and what your personal code of morality or your beliefs, your personal beliefs dictate. And that Venn diagram with the, in the middle, I think that this example brings to the fore all those different considerations or those rules, those standards of conduct. So that kind of analysis, it's like from your personal belief, you think you screwed up, you want to be honest, you want to withdraw, you don't want to keep the money you used to prepare. That may or may not be a good practical decision also, because if there is a lawsuit for breach of contract or a breach of confidentiality, it's not going anywhere really, because there is inevitable discovery, and this arrest arguably didn't impact the outcome of the mediation. Arguably, somebody could argue and may argue to the contrary. So I think being upfront, it's like contrary to all the training that doctors have, research shows if they say they're sorry when they screw up, it diffuses the situation. It makes it less likely for them to face a lawsuit.
Right. Now, it's an interesting thing that we always say that mediators really hardly ever get sued because we send people away with documents that aren't signed, not binding, and then the parties make their decision as to what they're going to do. But here is an area where mediators run a risk all the time when they do things in private. If they do something in private and breach confidentiality, there is always the potential of damages, something happening, getting sued. So I don't know. I don't know.
Do it, right? If it were easy and risk-free, everybody could do it.
Well, that's true. Okay, so we're going to now move to the next one. The only reason I don't leave this up is I can't see everything on my screen, but let's go to the next one. Okay, so the next one is, okay. The draft agreement is being discussed in a caucus, and you point out that the years of marriage were not added correctly, and there was another simple mathematical addition error. The error is not subject to argument. It's not a legal analysis. When you point it out, the attorney orders you not to disclose the error and sends you in to secure the agreement, sends you in, go into the caucus with the other party. Do you disclose the error, hide it, or simply not disclose it and make the offer? Okay, read it one more time because I'm not going to leave it up. The draft agreement is being discussed in a caucus, and you point out that the years of marriage were not added correctly, and there was another simple mathematical error. The error is not subject to argument. It's not a legal analysis. When you point it out, the attorney orders you not to disclose the error and sends you in to secure the agreement. Do you disclose the error, hide it, or simply not disclose it? Okay. Let's see. I'm going to put up some other ones. Okay, Jerry Scola. Jerry?
Yeah, does that work?
Yep.
Okay. I would not go in and explain I would not go in and try to get the agreement
Based on the error.
based on the error. He would have to fix the error before I would do that.
And why? Is there an ethical standard? Is it your standard? Or
well, it would be my standard, but I think it would also be an ethical standard.
Okay. Okay, let's go to Linda Spiegel. Linda?
Hi, can you hear me?
Yes.
Yeah. Hi, Linda.
All right, well, he basically said what I was going to say, which is the attorney may tell you what they want you to do, but they cannot order you to do anything. You are the mediator. You are in charge of the process. So you explain that nicely to the attorney and tell the attorney that if it is not corrected, you've reached an impasse, or you offer some other way of trying to get around it. But you don't go in and present false information to the other side and try and convince them to go forward with that. And I think if you are an attorney mediator, that's an ethical issue. You might want to analogize it to not presenting false information to a tribunal. It's not a tribunal, but it's similar. And just absolutely would not do it.
Does it make any difference whether it's a material fact or not?
No.
So even if it's immaterial, let's say the Social Security number was wrong.
That's very material. I don't think there's anything in an agreement that if there's an error is not material.
Okay.
Words.
Okay. So now let me go on to Laura. Laura Van Tassel.
I'm there. Can you hear me?
Yes.
Oh, good. Yay. Hi.
Hi.
I agree with everything Linda just said. I think that there is an RPC as attorneys that tell us that we can't provide false information. I think I would do exactly as she did. I think I would tell the attorney in caucus that can't do it, can't provide false information, and I'm not going to do it. We are at an impasse. I think I'd also have a private conversation with that attorney. I'd pull him out and I'd say, hey, listen, and we're not supposed to do that. As attorneys, we're not supposed to do that. And I completely agree with Linda. I wouldn't do it. By the way, I don't caucus for that reason.
Okay.
And RPCs that both Linda and Laura are referencing, RPC 3.4 and 3.3, candor towards a tribunal, fairness to opposing party and counsel. They're all in, they're not exact for this situation, but the underlying principles mandate that a lawyer not utilize knowingly and intentionally false information, whether it's insignificant or not. If it is significant, of course. If it's utterly insignificant, perhaps you have a different conclusion.
How about for non-lawyers? Okay, we have a non-lawyer mediator, not bound by an RPC. Is there anything that applies with respect to that?
Standards of conduct, is somebody who's familiar with
anyone have anything with respect to a standard of conduct? Okay, so I'll go to Barbara because she has a hand raised, and then we'll go back and talk about it. Whoops, Barbara. Unmute yourself, Barbara. Okay, Barbara's not there. Okay, so let me go to NJAPM's. I'm putting my reading glasses on. NJAPM's standards of conduct, and under the standard 6, quality of the process, a mediator shall promote honesty and candor among all participants, and a mediator shall not knowingly misrepresent any material fact or circumstance in the course of a mediation.
Well, to Linda's point, does the word material apply only to facts or to circumstances? Is it all circumstances but only material facts?
It just says, shall not knowingly misrepresent any material fact or circumstance. I can see where there would be mistakes that would be, let's say the date of marriage was 3 months off. Is that material? Might be, might not
be. Depends when the first kid was born.
Right. It could be immaterial. It could be material. In any case, it says material here in this standard. So, and of course, if you're doing a document, an MOU, and you're putting this into it, that's obviously covered by that because it's something you're doing affirmatively. Okay. I think we've asked everyone else. Would everyone put their hands down who has already asked a question and been answered, and only keep your hand up if you want to say something additional. Okay, Jay, one more time.
Yeah, I had a circumstance, not in a divorce mediation, but in a commercial mediation, where the one party's mediation statement had an incorrect table of interest and principal payments. How did I find it? Being an accountant in my past life, I added up all the numbers and I matched them back to the verbiage to see that they were in agreement. And it turned out that the table was wrong. I called the attorney right away because this was in the mediation statement. I explained to him what I found. He was beside himself because he couldn't believe that such a thing happened. It turned out that somehow my copy of the mediation statement had a preliminary schedule, and it was subsequently changed, but my copy wasn't changed, went out with the wrong one. I said, you got to let the other party know. I said, because I don't know what copy that other party had. I had no problem telling him this, and the attorney was compliant. I would apply that here. If I found, as the mediator, something incorrect, I would make a point of having it corrected before I went to the other side.
Okay, thank you. It's time for me to read an attendance code. The first attendance code is 3764. 3764. Let me ask one other party. Brad Ferenz used to be a judge, and he's the one who submitted this question. Brad, what saith you?
Well, this actually happened to me. The attorney is a very well-known lawyer. I'm not going to indicate who it is, and came from a very large, prestigious firm. I don't even say what county it is. And that lawyer was very angry with me because I did what everybody else is here saying. Say, look, I cannot go into the other side and represent that a document is accurate when I know factually it's not accurate. And I wouldn't. The lawyer was not happy. I presented the accurate number of years, and the case actually settled. That counsel has not been back for any future mediations. But I agree with it. I think it's an ethical obligation that we have, whether we are lawyers or lay folks that are mediating. I think the obligation to be honest and be candid is one that is endemic and absolutely necessary if mediation should be successful. There's got to be trust. There's got to be honesty. There's no sense mediating. Then you become an advocate, and that's not what we're here for.
And trickery has no place in this process.
Absolutely.
Right. Okay, let's go on to the next one. Okay, let's see where we are. Okay. Prior to the mediation, Larry, the lawyer, met with his client and discussed the mediation process. Larry told Carrie that everything said in mediation is confidential, so that nothing said could later be used in any kind of legal proceeding. Larry said this included not only communication between the plaintiff and the defense, but also prevents any discussions between Larry and Carrie from later being used in any kind of non-criminal proceeding, even if there were some kind of disagreement between Larry, the mediator, or the lawyer rather, and Carrie. However, Larry didn't provide Carrie any kind of written disclosure to this effect and didn't get Carrie's signature about this disclosure. Is what Larry said correct? Has Larry committed some sort of violation by failing to provide Carrie with a written disclosure about mediation confidentiality? Okay, everyone have that? Okay, now, let's see. Laura, do you still have your hand raised? Laura? No. Okay. Anyone want to answer this? Jay, you have your hand raised, but you have already talked about that. Glenn Milgram, let's call on you. Glenn, let me see where you are. Would you raise your hand, Glenn? Not raising her hand. How about Anju Dasani? Would you raise your hand? Not going. Okay, there's Glenn. Glenn?
The confidentiality has to come from the mediator, not from the attorney. The attorney who's representing the party is explaining what the process might be, but it's up to the mediator to set the rules for the mediation and how people are moving forward. Such as discussions had regarding certain information during mediation is obviously discussion of evidence that's going to come out at the time of trial. So you have to kind of intimate or explain to the party that when they talk about things not being raised at the time of trial, what type of information you're talking about.
Okay. Do you distinguish between, so you're saying that the any confidentiality agreement has to come from the mediator. Does it have to be in an agreement, something signed?
It has to be an understanding, and it should be executed by the parties so that you have evidence that they agreed to it or understood it. But if you don't have it, it doesn't mean it doesn't exist.
So there could be an oral agreement between all the parties or participants in a mediation that everything said is confidential, and you say that would be sufficient, but not preferable.
It's preferable to have the writing. Whether or not an oral agreement that's expressed is sufficient, it just leads to further discussion and litigation, which doesn't make sense at this point.
How about the point about what the attorney says to his client that that confidentiality also covers any discussion between the two of them, anything said between the two of them, if a subsequent problem between the two of them comes up?
The only time that may arise would be whether or not there's attorney-client privilege if there's a third person in the room and that third person is the mediator.
Okay.
That would be a waiver of the attorney-client privilege. Right. But another waiver could come about if Carrie client at some point decides to sue Larry lawyer. She's the owner of the privilege. She can waive that privilege. So it is inaccurate for him to say forever or never, our communications will be confidential. However, the conversations that include Carrie and Larry that are part of the mediation, even if he's a non-party participant, are governed by the confidentiality agreement that they all would have, and by the court rules if it falls within court mediation.
Okay, let's get Bob Lenrow. I've unmuted you. I mean, I've allowed you to talk.
Is it unmuted now?
Yes.
Yes, we can hear you.
First of all, I agree that it's the mediator's obligation to explain confidentiality to the parties. With respect to the lawyer's obligation is to get the client's informed consent to decisions. So the decision to mediate would have required the client's informed consent. And in terms of conversations between the lawyer and the client, you have to first look at the distinction of whether they were communications during the mediation, or are they mediation communications? And I believe that there's some gray there. But if it was, for example, a conversation that they had in caucus, I believe it would be confidential as to third parties. However, if the client raises a malpractice claim against the lawyer, then the confidentiality and privilege does not apply according to the UMA. And that would apply for the client's lawyer, the mediator, or any representative in the mediation.
So let me ask you a question. Is the lawyer mixing up confidentiality and privilege? Before the Uniform Mediation Act, people used to use confidentiality provisions and say things like, you know, you will not take me to court, and if you do, you'll pay my attorney's fees, blah, blah, blah. But since the passage of the Uniform Mediation Act, is confidentiality, a confidentiality provision, the thing that governs here? Normally, doesn't a confidentiality provision just say that you will not disclose to third parties? And if that, and the privilege under the UMA is really the thing that talks about what can be used when a person is in court.
Well, if you're asking me,
yes,
privilege applies only to testimony in court or litigation procedures such as discovery. So you have a privilege against having to disclose it in discovery, as well as the privilege against, as you can assert privilege in court to testify. So whether the lawyer's explanation was a little lacking, I don't remember the problem precisely enough, and it probably wasn't written enough to make that distinction as to whether he was talking about whether it can be disclosed in court or disclosed to the mediator or the other side during the mediation process. But I agree with you that there is a distinction. Confidentiality is much broader than privilege, and you can have a violation of confidentiality without violating a privilege.
So let's go back to the point about the attorney. And the attorney says to the client, everything that's said between us is confidential. And even if we had a problem between us, and Kim says, well, you could waive, it's the confidentiality or the privilege belongs to the client, not to the attorney, and they could waive it. But under the Uniform Mediation Act, doesn't the attorney, as a non-party participant, also have a privilege not to have to testify?
Yes. And the attorney also has the right to breach the confidentiality in the circumstances of a professional liability complaint.
Absolutely.
So.
Yeah. Well, let me read. The attorney does have it, just like a mediator has it, a privilege not to testify, not to have the other parties testify about what the mediator said. But there are exceptions. And here are two of the exceptions where what is sought or offered to prove or disprove a claim, complaint of professional misconduct or malpractice against a mediation party, non-party participant, or representative of a party based on a conduct occurring during the mediation. That's for non-parties and other parties. And for a mediator to prove or disprove a claim or a complaint filed against a mediator arising out of the mediation. So essentially, they have a privilege, but there's an exception to that. If you want to sue either the mediator or another party in there in the mediation for something that was said. So that's an exception to the privilege that is normally granted to people.
And it's very consistent with the exceptions to RPC 1.6. But
Right.
I would note that there is a scope of disclosure consideration.
Okay.
If the lawyer, or in this case, under the act, even a non-lawyer, wants to jettison the privilege in order to defend him or herself,
Mm-hmm.
You can't throw in all the bad stuff you learned in the course of your relationship with the person suing you. You can't say, and not only, but she also told me, she's
right,
does all these other terrible things. So be cognizant that it's not a wholesale dissolution of the privilege or the duty of confidentiality. It's to the extent necessary. I misspoke. It could be a wholesale dissolution of the privilege, because once it's waived and the floodgates can open. But with respect to confidentiality, which is, as Bob correctly said, broader than privilege, some consideration to how much disclosure is permitted needs to be taken.
Okay. Let me pose a question that sort of crosses a lot of these. When a mediator is in a is in a private caucus, is what the mediator says confidential? Or is it only what the party says to the mediator confidential? Anyone have a view on that? Mark, is your hand still raised?
Yes.
Okay, Mark, what do you think about that?
So I had my hand was raised for a different question,
Okay.
but I actually it's as long as it's privileged communications and related to the case, if it's in a private a caucus, then it should be privileged. If he says something that's not related to this and not related to trying to seek that, then that shouldn't be privileged.
No, okay, let me expand on my hypothetical. So they're in a private caucus, the mediator says something to the other party in the caucus. They now leave the caucus, and the other party that was in the caucus now says, while I was in the caucus, the mediator said this to me. Is that a breach of confidentiality?
To whom is he making that statement?
He's now making it in the general session to the other party.
Okay, but not to the outside world.
No. We're still in the mediation, so there's no third party confidentiality issues. It's a caucus issue, because everything I have read in standards of conduct say that the mediator shall not disclose anything said to him or her during a caucus. I have not read anywhere that says anything about confidentiality of what the mediator says. Now, you could do that by contract, but most agreements to media that I have seen don't cover what happens in caucus. Usually stated verbally when you go into caucus, and usually say something like, everything you say, here are my rules, everything you say in here is confidential. Or the other one, nothing is confidential unless you tell me. But in my experience, never talks about what I say is confidential. And it could be
vis-a-vis non-participants in the mediation. A mediator is bound under Rule 144, but only to the extent that it's outside the confines.
Yes. No, within the mediation. So let's say he says the mediator goes into a caucus and tells the party, you've got a very good case. Yours is much better than the other. Why they would say this, I don't know, because of value to people say these things, right? And then they go out of caucus, and the person he was in joint session says, the mediator just told me I have a really good case, and you ought to think about settling this. Is that a breach of confidentiality? Anyone have an idea?
Absent
Brad.
an explicit provision.
Yeah, Brad, are you still with us? No.
Well, yes, I am still here.
Okay.
I don't think it's a breach of confidentiality, quite frankly, but I also have situations where I might very well tell somebody, hey, you've got a very good case, but then I also follow it with, but I don't know what a judge is going to do.
Right.
I don't know what a jury is going to do. So it's always a matter of context. And as long as your context is honest, the stuff that you say to, folks in a caucus really, you shouldn't be concerned about it being shared. I don't know that there's anything that I would intentionally say. Maybe I might say something accidentally, but I cannot think of anything I would intentionally say that I would not be willing to say to the other side. If the other side said to me, hey, what did you tell them? I'd say, well, I told them that this is A, B, C, D, and E. I think I would probably share that with them because I think both sides have a right to know the questions that are being asked. I think we often get questions of, well, do you treat the other side like this? Do you tell them that they have problems? And well, they're asking me how I treat the other side. And I think we have almost an obligation to say, yeah, I ask them the same kind of stuff. I point out the problems with their cases. I point out the good things and the bad things in the hope to resolve the matter. So don't know, but that what I say is confidential. Though I will tell you, Carl, I am now going to look at my agreement to see whether I have in there that it's confidential or not, because I might. I might.
Okay, I think most people do not put into their agreements to mediate anything about confidentiality in caucuses. And I think it would be a good idea if people did do that and cover it explicitly. If you want to be covered, that should be in there as well. Just, some point I was thinking about. We have a question here that was sent to me by email. And it is it ethical for private mediators to be used by the administrative office of the courts in New Jersey to handle judicial misconduct cases? Okay, anyone have any thoughts about that? Has anyone ever been asked to be a private mediator in a matter of judicial misconduct? Laura, is your hand still unraised? Raised?
Laura's hand cannot be raised about this because I don't think judicial misconduct cases are mediated, period.
Oh, you don't think they are? Okay. Well, that's the end of that. I need to read the second code because we're getting close to being out of time. It's 7878. Again, 7878. Okay, I don't know whether we have time for maybe one. We have 3 minutes. No, we probably don't have enough time.
There is one comment that was raised, Carl, that I think you and I talked about in preparing for today that's worth mentioning, and that is that all the confidentiality and privilege issues go out the window in certain limited circumstances, like if there are indications of that a child is at risk. And somebody raised that, I guess Mark raised that in the questions as well.
Right. So well, actually, they're not in all the standards of conduct, by the way, about disclosure or the ability. They are in the ones applying to court connected, but I'm not sure that there is a universal obligation to there is for child abuse.
Child abuse.
No question about child abuse.
Mandatory reporters.
Right, but if there is spousal abuse, I'm not sure that there is a requirement if there's an allegation of spousal abuse to be a reporter with respect to that. Do you know, Kim?
I don't know. I'm confident that we're on the same page regarding children.
Yes, children. Okay.
With respect to adults, I don't know the answer. I suspect you're correct that there isn't an obligation.
Right. And which, by the way, I put that right to report those kinds of cases into my to my agreement to mediate, because if there is no right and I did it, I could get sued. But if it's in my agreement to mediate that I have the right to report, then they've agreed to it. So that's something you might also want to think about. Do we have any general comments from anybody? Anything else they want to ask? We prepared 11, I think 9 or 11 of these hypotheticals.
Mm-hmm.
I thought we would get through what, 4 or 5. I think you thought I was optimistic, Kim, and I guess I was.
We do have a couple of comments that are worth sharing for people who aren't following along on the Q&A. Somebody knowledgeable, Lynn, says there is no obligation to report domestic violence as distinct from child abuse. And Brad has, or judge, has asked about future crimes. If somebody says, I'm going to kill my spouse, what happens then? Certainly it waives the confidentiality under the rules of professional conduct if there's a threat to commit future conduct and you are involved. New Jersey is different from many other states in that regard. There's a mandatory obligation to disclose There are permissive obligations in other states. But that's something to look at both for lawyers and for laypersons. If there's a threat of imminent harm, what is your obligation to report and disclose to somebody, whether it's the target of the threat or an authority?
Right. And you've said, of course, that the RPCs carry over to attorneys who are mediating. If you're in a different profession, there may be similar standards of conduct that apply in your profession, a mental health professional, for example, that may carry over to you as well when you're a mediator. And those are things that you should think about and find out whether, in fact, they do. My wife was a psychologist, and I kept asking her about this until she told me to please shut up.
How many years are you married, Carl?
Let's see, since a long time. So, in any case, but that may apply to you as well. Okay, so we are exactly at 1:01. I want to thank everybody for attending. I hope you found that this type of work with hypotheticals is interesting. We could do it again because we have a lot of them. So thank you very much, Kim. Thank you very much for joining us. I hope you enjoyed it as well. Everyone have a good week. And let me just tell you the rest of the month. Next Monday at noon, we have the mock civil mediation webinar. The following week, we have Tech Time with Lawrence and Carl. And then the fourth Monday, we have the mock divorce mediation webinar. So those are the things that we have for this month. And we have even more for you next month. So have a great week, and we'll see you again.
Thanks to all.